15th Amendment was adopted on February 3rd, 1870, and states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any other state on account of race, color, or previous condition of servitude. It was the last of the Reconstruction-era amendments and designed with the hope of bringing freedmen more fully into American civic society. The relevance, applications, and limitations of the 15th Amendment reveal the larger story of voting in the U.S. First, it's important to know that when the Constitution was written, there was no provision in it concerning voting rights. In fact, the 15th Amendment itself was the very first national law to dictate who was allowed to vote. That is because voting, who could vote, polling locations, voting logistics, age, was, and in many respects still is, left up to the states. For example, in the early US, most states had property requirements for voting, but often anyone who met the property requirement, be they man or woman, black or white, was permitted to vote. Even Tennessee's first constitution permitted property-holding free black men to vote. Gradually, though, race supplanted class as the primary determinant of rights and social status, and states eliminated property requirements for voting only to replace them with race requirements. By the mid-1840s, white men, regardless of wealth, status, tax payment, or property ownership, in nearly all states were given the franchise, while everyone else, nearly 60% of the population, were not permitted to vote. Following the Civil War, freedmen, many having served as Union soldiers, were agitating for the vote. Republicans in Congress passed the 15th Amendment, giving the franchise to black men across the nation. For the last few decades of the 19th century, the U.S. saw meaningful biracial representation at all levels of government, local, state, and national. Southern states saw unprecedented expansion of education for children of all races, and the U.S. saw significant civil rights reforms during this period. However, it's important to go back to the language of the 15th Amendment. While it clearly stipulates that race cannot be a reason for denying the vote, it does not prohibit other requirements for voting. Between the end of Reconstruction in 1877 and the turn of the 20th century, all of the ex-Confederate states resurrected long-dead mechanisms for disenfranchising voters and added a few new ones. Property requirements, poll taxes, literacy tests, and even the horrendous grandfather clause ushered in the Jim Crow era, and Southern states effectively disenfranchised African American men, all without contradicting the 15th Amendment. Powerful whites in the South cared little that these limitations also impacted poor white men, who decades before had had unfettered access to the polls, as long as black men, as a voting bloc, were neutralized. So while the 15th Amendment was an important legislative action, it might be most notable for what it did not do. In the long run, it did not ensure the franchise for black men. Additional measures, such as the Voting Rights Act of 1865, were necessary to bring that about. And very importantly, the 15th Amendment was silent on voting rights for half the population, women, which did not come for another 50 years, a point we will revisit when discussing the 19th Amendment.